who are here today. A particular welcome to the petitioners and those who have asked for this hearing, who are the American Civil Liberties Union of Michigan, along with the International Women's Human Rights Clinic of the City University of New York. We welcome you. I also wish to thank the state for participating in this hearing, the United States, and to your delegation and the Deputy Permanent Representative who will lead and introduce the delegation. The hearing this afternoon will look at the human rights situation of children who have been incarcerated with adults in the United States. And the petitioners, we expect, will tell us much more about the specific laws in the United States, which allow children to be tried as adults and to serve sentences in adult prisons. This particular hearing also happens in the broader context of a rapporteurship which looks at the rights of children and adolescents, and a recent report on juvenile justice and human rights. I wish to recognize with me Second Vice President of the Commission and Rapporteur for the Rights of Children and Adolescents, Commissioner Rosa Maria Ortiz. Also with me is Commissioner Felipe Gonzalez, as well as Commissioner Rodrigo Escobar Hill. I'm also in my capacity here as the Rapporteur for the United States. Welcome to you all. I wish to offer the petitioners first an opportunity to make their presentation to us.
Thank you, Tracy. Good afternoon. I'm Cynthia Suhu. I'm the director of the International Women's Human Rights Clinic at the City University of New York. With me today are Bianca Cappellini, Cassie Fleming, and Mick Kincaid. And from the ACLU Michigan's Juvenile Life Without Parole Initiative, Deborah LaBelle, Ann Lynn Addis, and Jennifer Kirby. On behalf of our delegation, I would like to thank the Commission for holding this hearing on the important issue of the incarceration of children in adult prisons in the United States. And I'd also like to thank the United States delegation for being present here today, and we look forward to a constructive dialogue. For today's hearing, I will briefly discuss the applicable human rights standards that apply to children who are incarcerated in adult prisons. As an OAS member, the U.S. has an obligation to comply with international human rights law as reflected in the American Declaration and the International Corpus Juris on Children's Rights. This obligation applies to the actions of state governments and local governments as well as the federal government. These standards were recently articulated in the Commission's recent reports on juvenile justice and human rights in the Americas and its report on human rights of persons deprived of liberty in the Americas. These standards were also set forth in the Commission's 2008 Principles and Best Practices on the Protection of Persons Deprived of Liberty in the Americas. From these standards, I'd like to emphasize four overarching principles. First, the best interests of the child must be the guiding principle in dealing with children in conflict with the law. The state must provide age-appropriate services and treatment with the goal of rehabilitation and reintegration. This requires that the state develop a separate and specialized juvenile justice system, and that no child under 18 be sentenced, tried, or incarcerated as an adult. Further, children should only be incarcerated as a measure of last resort and for the shortest period necessary. Second, when the state incarcerates a child, it must guarantee his or her rights to life, physical integrity, and humane treatment. In particular, the state must take positive measures to protect children from abuse and violence, and it must separate incarcerated children from adults. The state must also is also prohibited from imposing cruel and inhumane treatment on children, including the use of solitary confinement. Third, children who are incarcerated retain their fundamental human rights to education, health care, adequate nutrition and recreation, and to maintain their family relationships. And the state must take positive measures to ensure these rights. And finally, the state must not discriminate against youth based on their race, socioeconomic status, gender, sexual orientation, identity, or other status. And non-discrimination concerns are raised by policies that lead to the over-incarceration of poor and minority youth, and the failure of the state to address the special needs and vulnerabilities of children, including girls and LGBTQI individuals. Deborah LaBelle will now address the laws and policies in the United States and the state of Michigan and the ongoing harm to incarcerated children resulting from the U.S.'s failure to comply with its international human rights obligations.
Thank you. In order to sort of focus our testimony here today, we have presented to the Commission a binder as well as to the United States, which includes many of the NGO's statements regarding this matter, as well as the testimony of Brenda Smith, who was a former commissioner for the Prison Rape Elimination Act Commission. And we have also provided to the Commission videotapes of two of the youth from the state of Michigan who were able to speak from inside on the direct harm they've experienced during that time. I understand there won't be a presentation of that during the commission. We're happy to provide a transcript of the testimony of those youth to the United States as well. I think I want to try to focus this in that there's really no dispute that when children come in conflict with the law, that it's often as a result of their very child status, and that the adolescence and its attendant consequences and characteristics, their impulsivity, their lack of appreciation of risk, their peer pressure, environmental conditions are closely intertwined and causally connected to what occurs and what their crimes and offenses often are. We also know that children have a unique capacity for rehabilitation if given age-appropriate resources and treatment. They grow up and they outgrow. Most of the adolescent development, say 90%, will outgrow any of their antisocial behavior. So the data is also overwhelming that children do better in juvenile facilities that are designed for them. Placement in adult facilities, we know, increases recidivism. It's not conducive to any correctional goals, and that's perhaps why the American Correctional Association, American Jail Association, the American Bar Association, and many of the organizations who are attentive to this issue have all said, don't do it. Put them in juvenile facilities. We also all know, everyone here, that youth are extremely vulnerable. Their size, their age, their lack of wherewithal and experience have resulted in all of the data saying they're, whether it's 5 or 50 times more likely to be sexually assaulted or physically assaulted in adult facilities and juvenile facilities. They are at greater risk and they are harmed greater in adult facilities. They have higher suicide rates. They don't get the education they need, and all of it leads to a kind of irreparable harm, placing children in adult facilities. And yet, we have anywhere from 100,000 to 250,000 per annum, depending on the figures you look at, that are in adult prisons and jails in the United States every year. We have at any one time, the estimate is 7,000 to 10,000 youth that are in adult prisons and jails. And we don't know exactly how many, because many states don't count certain children under the age of 18 as juveniles. So they don't even designate those people who are in their jails and prisons as children. The data that is collected is spotty. We simply don't know. We know in Michigan, which we've made an attempt to make as an exemplar here, to detail the harm, we know that in the last 8 years, over 2,000 youth were in the adult prison, just in Michigan, in one state. We know that at any one time, there are hundreds in the jails and in the prisons and in Michigan, and we know that they are not kept separate from children by either sight and sound or any other measure. So we know all these things, and yet we have all this harm we know about, and yet we continue to do this. And what I think I want to do is talk just briefly, because the youth cannot be here. And we have interviewed overall hundreds of youth, and just recently 68 youth who are under the age of 18 in the prisons in one state in Michigan, to have a sense of what is happening to them. And what is happening to them is what you might expect. A child's identity, as we know, is deeply linked to being a student and being a child of a parent. And yet putting them in adult jails cuts off those two senses of identities. They do not get education. They do not get education in the jails or prison. They are sent to adult prisons and jails that are far away from where their parents live. They are cut off as children from their parents. It is very difficult to visit, and they are charged with being adults so that if they want to call, they have to pay for calls that are often $4 for 15 minutes, and they have to buy stamps, letters, and envelopes, which they're unable to do. So when you put children in adult prisons, you take them out of their geographic area, and you cut them off from education. We surveyed 69 youth. Nearly half of them were not getting any education even in a GED setting, which is a small couple hours a day. They were told for many reasons they had to be 17 to get it. So if they were 14, 15, and 16, which Michigan puts youth as young as 14 into the adult prisons. In the jails, it can be any age. The youngest we have seen is 12 years old. They are restricted. It's made as a punishment to deprive them of education if they have misconducts. They are deprived of education if they are in solitary. So there are many restrictions, and they simply don't receive it. The issue with regard to youth and physical exercise in solitary is also well documented. 79% of the children we interviewed had spent time in solitary confinement in isolation. A third of them for much longer than 30 days. So we're not talking about a day or two, we're talking months. That's 24 and a half hours a day in solitary confinement. 24 and a half for young boys and girls. Some, if they were on, some in jails who were kept in solitary. One youth talked to us, he was in jail for 7 months in isolation and he never saw the outside, not once. There are 3 prisons in Michigan where youth spent 22 hours locked down in their cell, and that was for almost a year. The issues are replete with the problems you have when you put youth in adult facilities. They don't have enough food. The majority of children talked about being hungry. They're growing young men and women, and they're given adult food rations. Food is often taken away as a punishment. They are severely inadequate mental health services. You talked about in solitary, hearing voices and trying to get help, and yet no, for 3 months they were not seeing a counselor. Suicide attempts we're still measuring, but we know that they are higher in the youth facility than, for youth than they are for adults in the prisons. The medical care, youth in Michigan are required to pay for medical care. So a 14-year-old told us that even though he had gotten punched and hit and his teeth were hurting and broken, that he didn't have the $5 to get to access the medical care, so he simply lived through it. Those are the certain issues, and then we get to the physical harm. If the commissioners would watch the video, one very courageous young man told us about how he was raped within days of coming into the adult prison by 2 men. He was then raped in the showers. Then he was raped repeatedly. That when we asked him, did the staff know? He said yes. They laughed at one point. And after so many men were coming into his room, where he was housed with someone who was in his 30s and who had been raping him for 2 months, so many men were coming in, it became obvious to the staff of the violation. He was put in solitary. He is there now. He's in his 3rd month in solitary confinement, and that's their protection. He has not yet seen a counselor. The rape we all know about it. Children going into adult facilities and being housed with adult prisoners is a significant problem. The children are attacked physically by older, stronger, bigger prisoners, and they experience a great deal of sexual harassment and harm from the staff as well. In Michigan, girls are put directly into general population, and although they are not supervised by men, that's only as a result of a lawsuit that was settled 3 years ago that cost the state $100 million for the abuse and sexual assaults of young girls by custodial staff, and they removed men from the supervision of women. The state then removed that law, the protection of prisoners, from that law, however, and boys continue to be supervised by female staff, searched by female staff, touched by female staff, and viewed naked by female staff. This is a great deal of mental distress for young boys. The sexuality in the jails allows cross-supervision and viewing, and youth going into the jails for what are, I have to say, are many minor crimes. The majority of youth in Michigan in adult prisons are there for property crimes. Both of the videos that you would see of the Matthew, these are not their names, Matthew and Kevin, they could have served out their sentence and before they reached the age of 18 had they gone to a juvenile facility. But they have been assaulted and abused in an adult facility instead. So why are we doing this? The federal law, the PREA, the Prison Rape Elimination Act, does provide for protection of children under the age of 18. Do not place them in housing units where they will have sight, sound, or physical contact with adult prisoners. This does not address the issues of rehabilitation and education, but it was meant to protect them from the physical sexual harm that they experience. However, that law went into effect in August, and there is no compliance whatsoever in Michigan. None whatsoever. And I don't know what the state is doing. The feds are talking about doing an audit, but right now it is simply being ignored in Michigan. With regard to the Juvenile Justice and Delinquency Protection Act, that too provides that prison funding conditional on compliance with core protections afforded to youth. The applicable core protections include sight and sound separation of children from adults and jail removal in certain circumstances. However, the regulation appears to give way to the state's definition of what is a juvenile. So once a state says that a youth is no longer a juvenile but is rather an adult, and once a state says they are being prosecuted as an adult, which Michigan can do at any age and does routinely from 14 through 17, they are not under the compliance regulations of OJJDP. Finally, I would like to say that this doesn't have to happen. In 25 states, they have chosen not to put their children with adults in jails and prisons in this country. In 25 states, and in recently some of the largest states, Connecticut is moving their children out. It can be done. It's not a heavy lift. And it needs enforcement, it needs will, it needs monitoring, it needs compliance. The mixing of children with adults is just simply not necessary and can be resolved. And we look to the Commission to help to urge compliance on this. We've set forward in our pre-commission letter what we would like the Commission to do in terms of site visits, a hearing on precautionary measures, conducting information, gathering greater information in order to address this problem, which is affecting so many children in the United States in a very devastatingly way. And I would say, I just have to say too that we will be submitting some additional testimony with regard to the disparate racial impact on this issue. In Michigan, 78% of the youth are youth of color in the adult facilities, as well as some of the gendered issues that are going on. Thank you for your time.
Thank you very much to the petitioners. I wanted to give the state an opportunity to respond. Deputy Permanent Representative, and you could introduce those who will assist your delegation.
Thank you, Madam Commissioner. Distinguished commissioners, petitioners, invited guests, and Secretariat colleagues. My name is Lawrence J. Gumbiner, and I am the Deputy United States Permanent Representative to the Organization of American States. I'm pleased to be with you this afternoon. As this is the first hearing of the current period of sessions involving the government of the United States, I would like to take a moment to underscore my government's firm commitment to the inter-American human rights system. The defense and promotion of human rights is one of the bedrocks of the Organization of American States, and its member states must remain steadfast in our support. Consistent with this strong support for the Commission, including in the ongoing process of dialogue focused on reform and efficiency, my delegation is pleased to be here today to discuss how our government addresses issues of interest and concern to the Commission, and of course the issue specifically before us today. I would like to begin this discussion by introducing our distinguished experts who will be presenting on behalf of the United States government. First, two folks to my left. Let me introduce Jonathan Smith, who serves as Chief of the Special Litigation Section within the Civil Rights Division at the U.S. Department of Justice. And to my immediate left, we have with us Melody Haynes, Acting Administrator of the Office of Justice Programs at the Office of Juvenile Justice and Delinquency Prevention, which is all part of the United States Department of Justice. Madam Chair and distinguished commissioners, I will now turn the floor over to my colleagues to make their presentations. We look forward to a constructive discussion of the issues under consideration at this hearing. Mr. Smith, you have the floor.
Well, thank you for the opportunity to appear and provide testimony on this critical human and civil rights issue. I am Jonathan Smith. I'm the Chief of the Special Litigation Section of the Civil Rights Division, and I have with me today, assisting me, folks from the Civil Rights Division, Judy Preston, Shelley Jackson, Josh Delaney, and Karen Stevens. I'd like to thank them for their tremendous work on juvenile justice issues. The Civil Rights Division was created by the Civil Rights Act of 1957 and works to uphold the civil and constitutional rights of all, particularly some of the most vulnerable people in our society. The Special Litigation Section is responsible for protecting the civil rights of juveniles in the criminal justice system and persons confined to prisons and jails. Sadly, we are all too familiar with the damage to youthful offenders and to society that flows from incarcerating young people in adult facilities. In a prison in Mississippi, we found that prisoners as young as 13 years old were subjected to egregious sexual misconduct. We also found rampant excessive use of force on youth by staff and shockingly high rates of harm and risk of harm from youth-on-youth violence. In a Louisiana jail, juveniles await trial on adult charges in a facility that is rife with violence, where inadequate medical and mental health care have led to repeated suicides and suicide attempts and other trauma, and where prisoners' physical surroundings are in a state of dangerous disrepair. We've investigated and litigated cases that address unconstitutional conditions of confinement in juvenile facilities, unconstitutional conditions of confinement for juveniles in adult prisons and jails, and due process and equal protection violations by juvenile justice systems that result in increased incarceration of juveniles, increased removal of juveniles to the adult system, and the overrepresentation of minority youth in the correctional system. The bulk of our work regarding juvenile incarceration has focused on juvenile facilities. However, in recent years, we have conducted investigations or brought litigation in 4 jurisdictions where juveniles charged or convicted as adults are held in adult prisons and jails. These cases have revealed disturbing conditions. In 2012, we concluded an investigation of Walnut Grove, a privately run prison in Mississippi designated to house youth as young as 13 who are convicted as adults. In addition to high rates of physical and sexual abuse, we found that these young prisoners were subjected to inadequate medical care and mental health services and an unsafe and dangerous physical plan. The prison was so poorly supervised and correctional staff so poorly trained that they often used a pepper spray fogger inside housing units, a practice that is both dangerous to prisoners and to staff. The conditions were so severe that we recommended to the state that all prisoners ages 17 years of age and younger be removed and placed in juvenile detention facilities or in special housing units separated from adults. The United States is negotiating with the state, and litigation brought by private advocacy organizations, including the ACLU, has subsequently resulted in an injunction against the worst practices in this prison. While extreme, unfortunately these abuses are not unique to Mississippi prisons. We are currently involved in litigation seeking an injunction to reform the jail in New Orleans, Louisiana. In addition to excessive violence, inadequate medical and mental health care, and abhorrent environmental conditions, prisoners are subjected to a high rate of sexual assault. According to a Department of Justice survey, 7.5% of prisoners in this jail say that they've been sexually assaulted while incarcerated. Youthful offenders are the most vulnerable to sexual assault and to many of the deprivations of rights. I recently visited the housing unit for youth being held as adults and spoke to the prisoners that were confined there. These young people are idle, live in fear of each other and staff, deprived of meaningful access to educational services and physical activity, and denied age-appropriate medical and mental health care. In other cases, the division has negotiated agreements to ensure that youth in adult jails are protected from excessive periods of solitary confinement, have access to an education, including special educational services, are provided equal educational opportunities regarding gender, and are kept separate from adults. Increasingly, the division is working to ensure that youthful offenders are not unjustifiably confined to adult prisons and jails. The policies and procedures for removal of a juvenile to the adult systems are governed by state law and vary widely across the country. The rate of removal and the rights of children in the process can be significantly different from state to state. No matter where they are confined, however, all juveniles are entitled to equal protection of the laws and fundamental guarantees of due process. The consequences of removal to the adult system can be severe for both the child and for public safety. As a 2010 study showed, children who are adjudicated in the adult system have higher rates of recidivism and other antisocial behavior than their similarly situated counterparts in juvenile court. Moreover, a 2008 study found that children considered for transfer may be more inclined to plead guilty in order to avoid the potentially serious consequences of trial in the adult system, thus suffering greater consequences in the juvenile system. In 2012, in Shelby County, Tennessee, we completed our first investigation of a juvenile court system. Among other findings, we concluded that the procedures used to transfer children to adult criminal court contained serious due process violations and in some cases deprived the child of meaningful assistance of counsel. In addition, we found that these transfers violated African American children's constitutional rights to equal protection under the law. We found that African American children had a greater chance of having their case transferred to the adult criminal court than white children. Our study showed that these differences could not be explained by factors other than race. We worked closely with the court to develop a comprehensive reform plan. The county and the court have signed an agreement with the Department of Justice to address both our due process and our equal protection findings. The agreement requires adherence to due process requirements in transfer cases and will consequently reduce the number of children held in adult facilities. Among the requirements in the reform plan, the court will hold transfer hearings with proper due process protections, provide an accused child with the opportunity to meaningfully confront the evidence against him, and to have meaningful assistance of counsel. Furthermore, the agreement requires data collection, review, and evaluation of transfer decisions, including the creation, as necessary, of an action plan to reduce factors contributing to the overrepresentation of minority youth in transfer recommendations. The problems we found in this court were far from unique. We hope that the reform plan we developed with this court will serve as a model for others to address these issues. In addition to cases to protect the rights of young people involved in the criminal justice system, the Civil Rights Division was an integral part of the Department's promulgation of the final national standards to prevent, detect, and respond to prison rape. The national standards were issued pursuant to the Prison Rape Elimination Act, or PREA, and became effective for states and localities on August 20th, 2012. These standards include strong protections for youth housed in adult correctional facilities. Separately, juveniles under juvenile court supervision are subject to the requirements of the Juvenile Justice and Delinquency Prevention Act. My colleague from the Office of Juvenile Justice and Delinquency Prevention will testify regarding that statute. The PREA standards impose 3 requirements for juveniles placed in adult prisons and jails. First, a youthful prisoner may not be placed in a housing unit in which he or she will have contact with any adult prisoner through the use of a shared day room or other common space, shower area, or sleeping quarters. Second, outside of a housing unit, jailers either maintain sight and sound separation between youthful prisoners and adult prisoners or provide direct staff supervision when youthful prisoners and adult prisoners are together. Third, jailers must avoid placing youthful prisoners in isolation as a means to keep separate from adult prisoners. Absent exigent circumstances, youthful prisoners must receive daily large muscle exercise and any legally required special education services. They must be provided with access to other programs and work opportunities to the extent possible. The standards will hopefully have a broad reach. All federal prisons and jails operated by the Department of Justice must comply with the standards. Moreover, States that fail to comply with the standards risk a financial penalty that will reduce the Department of Justice's corrections-related grants by 5%. The penalty will be used by the state for corrective measures. Finally, in order to be considered PREA compliant, each facility must be audited by an independent auditor at least every 3 years, and the relevant agency must publish the results of the audit on its webpage. Importantly, we are incorporating the standards in our civil rights enforcement efforts. In December of 2012, we entered into a proposed consent decree that will require a jail to develop and implement policies, protocols, training, and audits consistent with the requirements of PREA and its implementing regulations. The injunction expressly requires the implementation of PREA standards regarding housing, supervision, protective custody, and developmentally appropriate mental health and programming services for youthful offenders. We are waiting for the court's final approval of this proposed decree. The Department of Justice engaged in a range of activities to carry out our commitment to ensure that juveniles do not unnecessarily enter the adult criminal justice system and that conditions for juveniles who do enter that system meet the requirements of the United States Constitution. I look forward to your questions.
Is it on? Okay. Good afternoon. I'm Melody Haynes, the Acting Administrator for the Office of Juvenile Justice and Delinquency Prevention, and thank you for the opportunity to be here today to discuss this critically important issue of children being incarcerated with adults. At OJJDP, what we call our office, it's our job to provide national leadership to states, communities, and tribes about best practices and programs for juvenile justice. We help them identify the best practices to assure that the kids who come into contact with the criminal justice system are treated fairly and appropriate. We at OJJDP also do research to determine what works and what doesn't work and what should be best practices. And we provide resources to states and communities or detention facilities, such as training and technical assistance. Based on our enabling legislation, we have a vision at OJJDP of a nation of children who are healthy, educated, and free from violence. And it's our mission to achieve that vision, to provide leadership to states and communities that should their children come into contact with the criminal justice system, it is first of all rare that they have that contact, second, that it is fair, and third, that it is beneficial, that the youth who have to come into contact with the system are better off as a result of that contact. The guiding principles for this is found really in our Enabling Act from 1974. Congress contemplated that youth who offend and end up in contact with the criminal justice system should clearly be treated differently from adults. This mission is based in part on the research that clearly indicates, as Ms. LaBelle alluded to, that children are not mini adults. In fact, research indicates that brain development in children is sometimes not complete until they are 23, 24, 25 years of age. Until that critical point of maturation, children are susceptible in their decision-making to peer pressure or lack of impulse control. And I'm sure each of us in this room can remember decisions that we made at the age of 16 that we certainly would not have made at the age of 26. So in accomplishing this mission, we at OJJDP engage in a variety of activities with the states, communities, and tribes to improve their juvenile justice systems. This includes grants that we give to all states and territories that support best practices, research, training, and technical assistance. Our Formula Grant Program supports state efforts to improve their juvenile justice system and to meet the goals of our act. To receive a full allocation of formula dollars from our office, the states and territories must comply with 4 core requirements. Those core requirements are deinstitutionalization of status offenders, and translated, that is, not arresting kids for crimes that wouldn't be crimes if they were adults, like being a runaway, a truant, a minor in possession of tobacco. Second, to receive full funding, they must comply with separation of juveniles from adults in detention facilities and institutions. Third, if a child is placed in an adult facility and if they are separated, they have to be removed within a minimum period of time, between 6 and 48 hours, depending on the rural nature of the location. And fourth, final core requirement is the state must prove its reasonable efforts to reduce the disproportionate minority impact on youth of color and with disabilities in the juvenile justice system. So these core requirements reflect the principles that are inherent in our enabling legislation, that children who are not a risk to society or to themselves should not be detained or removed from their existing support systems, from their communities, from their families. And it supports the principle that youth are vulnerable, akin to the brain development I just talked about. They are vulnerable and should not be subjected to punitive and potentially harmful conditions of incarceration, and that kids should be treated fairly, rare, fair, and beneficial. So why did Congress put such a premium on keeping kids out of the criminal justice system and separated and segregated from adults? Research and common sense have told us, and much of it is based on the research we've done at OJJDP, that the kids that get into the criminal justice system, and the minute they cross that threshold to detention or incarceration, whether it's juvenile incarceration and particularly if it's adult incarceration, those kids do not do well. That is the single variable that predicts what the outcomes of the futures of these children are. That variable alone predicts a higher recidivism, particularly for kids that go in the adult system. These kids drop out of school, they're less employable, they have a higher incidence of mental health issues, and can in fact be the frequent flyers as adults that use our health system. So it's not just a matter of social justice, it's also a public health issue. We at OJJDP have had a good track record since 1974, when these core requirements were implemented. Since 1974, we've decreased the detention of status offenders by 97%. We've decreased the instances of youth held with adults 98%. And the instances of youth held in adult jails and lockups have decreased 97%. And in fiscal year 2011, every state was in compliance with the requirements for reducing racial and ethnic disparities. Now, I am certainly not saying that there is not work left to be done, but there has been progress, and significant progress, made since 1974. With regard to the transfer of children to the adult system, each state in the United States has its own criminal justice system, as well as the territories. They can all be very different. The definition of a juvenile is defined by state law within each state, and you won't find it in the Juvenile Justice and Delinquency Prevention Act, a definition of juvenile. And it's not a matter of the regulations giving way to a state's definition. It is the legal interpretation of our act that we have jurisdiction over those children in juvenile court and not those that have been waived up by a state. So with compliance of the core requirements for purposes of OJJDP, we calculate those kids that are in the juvenile court system. Currently, 13 states have the criminal age of responsibility before 18, and that law resulted in 175,000 youth going to criminal court each year automatically. All states have transfer laws that allow or require criminal prosecution of some offenders. Between juvenile transfer law and the upper age of jurisdictional limits, it's estimated that close to 2.2 million youth younger than the age of 18 are subject to routine criminal processing as adults every year in the United States. We have learned that kids who go into the adult system have a higher rate of recidivism. Their time for reoffending is shorter, and the likelihood of those to reoffend with a violent offense is the highest. It is our mission at OJJDP to provide leadership nationally for policies and best practices that we know exist and that are consistent with our law, which suggests that children should at all costs be not sent into the adult system, and that we seek alternatives to detention completely where appropriate and when not at the expense of public safety. Thank you.
I wish to thank both the petitioners and the state. I have to say I find the information we have received alarming. It's an instance in which what the state has said indicates an even graver and more serious situation than the specific questions which have been put before us by the petitioners. I want to turn to my commissioners to ask their thoughts and to ask questions. Commissioner Rosa Maria Ortiz first, but then Commissioner Escobar Hill, who is, and I neglected to mention this at the outset, the rapporteur with responsibility for dealing with the rights of persons deprived of liberty. Vice President, Commissioner Ortiz.
Muchas gracias, muy buenas tardes. Muchísimas gracias a las organizaciones de la sociedad civil que nos brindaron información y un llamado de atención sobre este problema, y muchísimas gracias a las autoridades de los Estados Unidos de América por las respuestas y la información que nos están brindando. Efectivamente, la Comisión está llevando a cabo un trabajo muy intenso para acompañar a los estados a través de este informe que ha realizado la Comisión, acá está en inglés, Juvenile Justice and Human Rights in the Americas. Por lo tanto, hemos logrado desarrollar criterios muy claros que pueden acompañar a los esfuerzos de los estados para encarar estos problemas. Estamos alarmados por la información, no teníamos realmente una idea de lo grave de la situación y muy agradecidos por haber traído esta posibilidad de esta audiencia que nos permite conocer el problema y enfrentarlo. Y tienen en la comisión expertos que pueden acompañar sus esfuerzos porque es una tarea muy grave y muy grande. Nos gustaría adelantar que estaremos muy interesados en conocer más la información con datos, de manera a poder hacer un seguimiento y un acompañamiento para esta urgente acción que precisamos, porque vimos en toda la región, en todas las Américas, los estados están haciendo y han hecho cambios legislativos, de políticas y también de prácticas, y existen buenas prácticas en la región que pueden ser utilizadas, como seguro que existen también en los estados, dentro de los Estados Unidos. Pero creo que las respuestas del Estado nos brindan ya la información de que son conscientes del problema y también que ya han tomado algunas iniciativas encaminadas a resolver esa costumbre que antes de la Convención de los Derechos del Niño era muy fuerte, pero que efectivamente la Convención ha producido un cambio en la región. Sabemos que Estados Unidos todavía no ha ratificado esta convención, pero por las respuestas dadas vemos que los estándares allí desarrollados y la práctica desarrollada están siendo llevadas a cabo. Porque la privación de libertad de niños y adolescentes no es la respuesta a cuando los adolescentes o los niños cometen una infracción a la ley penal. Es la última respuesta, pero siempre esa respuesta, aunque sea la de privación de libertad, debe garantizar la protección y la finalidad de la medida, que es constructiva, que es rehabilitar a ese niño. Cuando que lo que estamos viendo es más el castigo y es más el daño que producen los adolescentes, lo cual nos alarma, ¿verdad? Y me quedo aquí para dar lugar a mis otros colegas a hacer otros comentarios. Gracias.
Quiero agradecer la información presentada por los peticionarios y también por parte del Estado. Realmente en esta tarde se ha puesto sobre la mesa un problema verdaderamente grave y muy preocupante para el sistema de derechos humanos del continente. En el continente es muy grave en general la situación de las personas privadas de la libertad y encontramos que en los distintos estados se presentan problemas muy específicos. Por eso me parece muy grave la situación que se nos ha puesto de presente, porque un principio básico e inderogable en materia de derechos humanos es la separación en los centros carcelarios de los niños de los adultos. Es absolutamente inadmisible que en pleno siglo XXI todavía existan en los estados establecimientos carcelarios en donde hay niños conviviendo con los adultos, porque eso se presta para las más graves violaciones a los derechos humanos. Realmente, cuando un niño infringe la ley, realmente ese niño debe ser es merecedor de un cuidado y de unos tratos especiales. Un niño no puede estar en una cárcel de adultos. Un niño lo que necesita es un centro de rehabilitación en donde le den educación, en donde le den un muy buen trato, en donde le den ayuda y asistencia psicológica, porque cuando un niño delinque, no es porque él quiera, sino que fundamentalmente hay problemas graves en su familia. Entonces, por eso se requieren la existencia de centros especiales y la separación de los niños de los adultos. Y que el Estado sea muy cuidadoso en ofrecerle al niño educación, resocialización, condiciones adecuadas de alimentación, etcétera. Porque de lo que se trata cuando es un niño, a diferencia de un adulto, en el caso del adulto cuando está en prisión, es con un criterio también de mejoramiento y de prevención del delito. En el caso del niño, lo fundamental es el interés superior del niño. Por esas razones yo agradezco la información. Es un tema que va a ser especialmente estudiado en la relatoría y para ello nos gustaría conocer qué mecanismos de supervisión se están promoviendo por parte del gobierno central para investigar y sancionar estas prácticas cuando a los niños se internan con los adultos, porque aquí lo fundamental es que se haga respetar el principio y cuando hay niños con adultos tiene que haber responsables porque es claro que se están contraviniendo los principios básicos de los derechos humanos. Y también me gustaría conocer las políticas y las medidas dirigidas a la rehabilitación y a la educación y a la creación de centros especiales para niños. Entonces, básicamente quería pedir información básicamente sobre estos temas, más que preguntas son pedidos de información por el carácter muy general y por el poco tiempo que tenemos.
Commissioner Gonzalez.
Gracias. Bueno, le agradezco las presentaciones a las dos partes en la audiencia. Yo quisiera decir como una cuestión inicial que cuando comencé a revisar la información que se nos proporcionó y a escuchar las presentaciones, pensé que el asunto se refería fundamentalmente al hecho de que personas adolescentes estuvieran en los mismos recintos físicos, digamos, en el mismo edificio, por así decirlo, que los adultos, lo cual ya representa un problema, como aquí se ha dicho por mis colegas, pero resulta que además en algunos casos se trata de que están físicamente juntos, lo cual es de una gravedad muchísimo mayor todavía. Yo quisiera decir que, por ejemplo, a mí me ha tocado a lo largo de los años, hace mucho tiempo, de antes de ser comisionado, participar en distintas iniciativas de reforma de justicia criminal en América Latina. Recuerdo proyectos impulsados por USAID en que precisamente uno de los elementos que se trataba en América Latina era de separar a los menores de los adultos como una cuestión elemental. Entonces, me sorprende muchísimo lo que aquí se nos plantea. Ahora, yo entiendo la buena disposición del gobierno federal a este respecto, aunque, claro, me pregunto si no se podrán tomar iniciativas adicionales. Me preocupa un poco, para ser franco, el hecho de que se plantee esto de manera evolutiva, que se diga, bueno, hace 40 años estábamos en tal situación, ahora hemos mejorado, estamos en tal otra. Esto es una cuestión básica y urgente, ¿no? Me parece que sea una cosa que se pueda analizar como progreso paulatino a lo largo de las décadas. Desde el punto de vista del derecho internacional, evidentemente es una cuestión absolutamente elemental y urgente. Y no me queda claro tampoco, escuchando las dos partes, al final no me queda claro un asunto, porque se nos dice que por el gobierno federal que se ha producido una clara disminución en las personas, en los niños y adolescentes que estarían en estos recintos, pero por otra parte lo que decían los solicitantes de la audiencia es que muchas de estas personas no están ni siquiera contadas en algunos estados. Entonces, yo quisiera saber del gobierno federal qué sucede con eso, o sea, las cifras que ustedes manejan son del universo completo o efectivamente, como señalan las peticionarias, en realidad ciertos estados no tienen estadística al respecto, por lo tanto no podemos tener un panorama completo. Gracias.
I just wanted to say, by way of observation, that I actually really value the candor, the clarity, and the commitment of the federal government. But I share Commissioner Gonzalez's concern about the urgency of reforms. When the petitioners say that 25 states still haven't achieved what the other half have, really what I'm interested in hearing is what are the specific initiatives and initiatives which hope to bear fruit very quickly, which will change the situation in those other 25 states. And also I'm just curious, although I know there isn't time to fully ventilate and discuss these issues, to what extent are the young people being incarcerated, being empowered and supported through legal aid or otherwise to ensure meaningful protection for their human rights in the context of incarceration. Because in the meantime, at the very minimum, there should be full support for young people to ensure they have the best protection of the law. I just wish to give an opportunity to both the petitioners and the state to respond. We have had a lot to say, but can I offer you a few minutes to answer and to, I'd be interested in hearing whether you have some very concrete proposals for the state, which we may all bear in mind as well.
Well, thank you very much for your comments, too. I think that what we can both agree upon is, although there is PREA, the Prison Rape Elimination Act, it does not require youth to be kept out of adult facilities. Aside from the difficulties of monitoring that and the lack of monitoring that's going on and the weakness of the act, which is detailed by the former commissioner, Brenda Smith, in our testimony, it does not require children to be kept separate. And therefore, even if, and it has resulted in those instances where there's some acknowledgement of PREA, of increased solitary confinement. So it is a problem. And the OJJDP, of course, has the massive problem of not recognizing that children are those people under the age of 18. And that just because a state says a 14-year-old may be treated as if an adult, that cannot convert a child into an adult. And so we do have deep concerns about the numbers. We think that the states, when we have asked states for the number of juveniles or in their facilities, they give us sometimes zero because they have no juveniles in their facilities. They only have adults in their facilities, even if they're 14. So I think that there's great difficulty in providing data if you're only required to look every 3 years at a facility. So the monitoring of the facilities and the data collection is, I think, sorely lacking. I don't know either if any state has indeed lost funding as a result of their noncompliance. It's hard for me, I mean, I just don't know, that's not it's not to say that it doesn't happen, but certainly in the states that we've looked at, there's been no loss of funding, and yet they appear on the surface quite noncompliant with basic OJJDP regulations. So I think that the state can do much more in terms of monitoring, collecting numbers, enforcing what they have. But I also think that there has to be some initiative to define on the government in compliance with the laws that a child is a child under the age of 18. And that the placement of children in adult facilities, in adult cells, which is routine, not exceptional, can no longer be tolerated because of the harm that we all know that it causes. Thank you.
I didn't wish to interrupt you, but I understand, and I confess there was a measure of confusion, that there is an opportunity to hear the audio
yes.
of some of the testimony. No, I understand, and Commissioner Rosa Maria Ortiz is, as rapporteur, is very keen that we have an opportunity to hear it. Is there a possibility that we may hear one of the two?
Yes.
For a couple of minutes rather than both, which
yes.
which will give us a chance to also hear from the state immediately
yes.
after. Thank you very much. Is it ready?
It is ready. Matthew.
I got into several fights when I was in the county. I got punched in my face, and my whole eye was swollen, and my lip was gashed. They removed me from the cell, and they put me into another adult cell. I got into a fight in that cell as well, and they removed me, and they put me in another cell. Yes, but a lot of it went unreported. I witnessed sexual assault and physical assault or other use. Usually in the shower, when you go shower, because you have to shower with a lot of other men, and they usually happen, the men come in, you take a shower and they're all dressed, and they just jump you, and they pin you to the ground, and then they get to do whatever they want.
Since it's in the showers, if guards wanted to stop this, they could.
Yes.
After 7 months in the jail, were you then taken into an adult prison?
Yes. They bunked me with another adult. I was sexually assaulted. He was in his 30s. He said that he was going to stab me if I told anyone.
How long were you kept in a cell with the man who sexually assaulted you?
2 months. Yeah, almost every day. And I was assaulted in the shower by another man. When I was there, I knew the staff knew that it was happening because guys would come in and out of my room without authorization. And the staff made a comment to me when one of the guys walked out of my room, and he laughed at me. He said, "That's what happens to fags." While they were monitoring my cell, there were still guys that would come to my cell door or come inside my cell, and they didn't say anything or stop it. I remember the first time that I got raped in prison and wondering, where is the sex act that is supposed to stop people from trying to rape me? I didn't understand. I wanted to go tell the people that were working there, the CLs, but when they laughed at me, when one of the guys came out of my room, I knew that I couldn't tell anyone and be taken seriously.
Were condoms used?
No, there are no condoms. It's scary because I have to get tested every 6 months because I don't know if I got infected or someone had a disease, and it's scary because now I have to live like the rest of my life wondering, did I contract the disease from one of the underprotected sex that I had been. I got into several fights when I was in.
Thank you very much. Can I give the state an opportunity to respond?
Thank you very much. I think perhaps some clarification is needed, particularly, Commissioner Gonzalez, your question about the data and how can it be different. I need to back up and kind of, as a fundamental, the United States system of jurisprudence uniquely allows each state to devise their own criminal justice system. It is not for the federal government to dictate what each state defines within their criminal statutes and the age of responsibility. There is no doubt that the policy promulgated by our office as national leaders is the policy of not incarcerating certainly children with adults, but also deterrence from detention whenever possible and reasonable. But again, it is a matter of we are in a situation where we try to provide incentives to states to meet these policies and these best practices rather than having the tools to force them. And I'll defer to my civil rights colleague to talk a little bit more about that. But in terms of the dollars that we give to the states, they are incentives for them to comply with the policies. There is, in fact, one state in the United States that chooses just not to participate. And we cannot force them to participate in accepting our money and endorsing these core requirements. We can try to provide incentives, and we do that with our funding. You will see in some of the funding streams that we get, even though they're diminishing, that we provide incentives to states for additional money to invest in programs that reflect these best practices. With regard to the numbers that you inquired about, at OJJDP, our statute is very clear that we have jurisdiction of kids that are in the juvenile court systems of states. Our dollars do not, cannot be limited once they leave that designation of juvenile court. The numbers that we have collected, Commissioner, of kids who are in juvenile court is solid data, and that's where we got that 97% and the 98%. Those are kids in juvenile court. Kids who are waived up into adult court, we are not required to monitor as part of our funding streams, and that is what Ms. LaBelle was referring to. There is no mandatory requirement for states to report the number of kids that are waived up and what they're charged with. Even though it would be a best practice, there's really no mechanism to force that at this point. 2 documents that I believe we electronically attached provide a very good explanation of how those numbers are different and what the trends have been of the numbers that we do have. And also that there has been a significant trend among the states to increase the number of kids that are waived into adult court. Again, a matter of individual legislatures in states implementing those laws that, frankly, are contrary to the best practices that are recommended by OJJDP. We have withheld funding from 8 states last year for not complying with the core requirements of the Juvenile Justice and Delinquency Prevention Act. And we try very hard to give technical assistance and training to those states to help them to come into compliance. For us, it often becomes a delicate balance of the federal government coming in and telling them what they have to do versus giving them incentives to really begin a culture change in their juvenile justice system of how they treat their children.
Thank you. Commissioner Gonzalez, like you, I started doing prison reform work almost 30 years ago, and am somewhat haunted by the number of conversations I had with clients over the years that resemble the one that we heard on the audio tape, and understand your impatience with reform, and share that, and share what I think Dr. King called the fierce urgency of now, and the need for us to take important measures and steps to do that. And I am proud to be part of this Civil Rights Division, which has made a deep commitment to work on these issues. And I want to just emphasize that as we, our constitutional structure permits both the public enforcement of our laws through the work of places like the Civil Rights Division, as well as nonprofit, and I did this work as in a nonprofit environment, as well as private litigation and private law firms. And so it's a textured and structured enforcement of the Constitution. And while it hasn't yielded the result we all would like there, I think there's some real important promise there. I want to just make some quick points, and I know we're almost out of time. There is a deep commitment by the Civil Rights Division to work on these issues, and we have refocused a lot of our attention on trying to identify those systems and structures through the operation of our courts that unnecessarily put children in the adult system. And our work in Shelby County and litigation in Meridian, Mississippi is focused on that issue. We think keeping kids out of the adult system is a better strategy than trying to fix the adult system with limited resources. And so while we work on issues of what happens to kids in the adult system, we're putting some real emphasis on keeping kids out. The Prison Litigation Reform Act standards are brand new. The impact doesn't start until October 1 of 2013. I suspect that we're going to be here worrying about whether we can strengthen those and do a better job enforcing those and have them have a greater impact as time goes on. But that is a strategy that's just going into effect, and there's real promise. This is the 50th anniversary of the Supreme Court decision in Gideon versus Wainwright, where the right to counsel was established and has now been extended to children. And as part of our work, we're enforcing that right to counsel, both in our work in Shelby County and Meridian, Mississippi, and other places that we're looking at. And I think that also meaningful access to counsel, what happens to kids when they walk into a courtroom is going to make a big difference on whether they end up in the adult system, whether they get confined to the juvenile system, and what happens to them when they get locked up. And so that is a place where we're putting emphasis to try to do some work. And I'm sorry we didn't have more time to talk. There's a lot to say. This is an issue that is, deeply important to the Civil Rights Division and to OJGDP and to others. We care deeply about it and would welcome further dialogue to see how we can strengthen our work. Thank you.
Want to thank both sides. We're out of time. We know there are some specific recommendations to us. We welcome, I think we've probably received those already in writing. And we also note the state's commitment to further dialogue and discussion. The Commission, it remains a space where some of that can take place. And the various rapporteurships are deeply interested in this question and will continue to follow up. Thank you, everyone.
Thank you very much.